Question for so many people. I've got just the guest for that very question. Let's get right to Marcus Childress, former January 6th Committee Investigative Counsel, and Rebecca LeGrand, a constitutional lawyer and defense attorney. I got to ask you, I mean, first of all, you've already heard, Marcus, and you heard obviously from Noah as well. The January 6th Committee report and the information that was gleaned and really shown to the country and the world was relied a lot by this judge. That was criticized by Trump's counsel because they took a lot of issue with what was presented in those hearings. Were you surprised it was relied on to the extent that it was?
No, I wasn't surprised at all. Look, we trusted our process. We trusted that we went where the facts took us. And you heard arguments about bias from our committee and maybe the qualifications of our committee, but there were no assertions contrary to our actual findings of insurrection, that former President Trump incited this insurrection. And you saw the judge actually discuss that in her opinion of the reliability of our investigation and how methodical we were with that. And I think that it was a great confirmation of the work that we did here today. And I was happy to see that she confirmed it. I
mean, you almost had it confirmed, well, you explicitly had it confirmed by one Senator Mitch McConnell right after all the presentation of the evidence back after that impeachment. I mean, listen to what he had to say. I mean, he was aware and confirmed it then. Listen.
The House accused the former president of, quote, incitement. That is a specific term from the criminal law. There's no question, none, that President Trump is practically and morally responsible for provoking the events of the day. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
And yet, Rebecca, the holding tonight was that, well, because he was the president, he is not accountable under that letter of the law.
That was the holding today, and I share Marcus's view that this was a careful, detailed opinion that confirmed a lot of things that folks have been arguing about and held and addressed directly a lot of Trump supporters' arguments in a context where there was due process, where there was a chance to cross-examine witnesses, where Trump could put on witnesses and did. So all the due process you want. And after listening to many days of testimony, reviewing the relevant portions of the January 6th report, this judge found this was an insurrection. This was an insurrection, and Donald Trump was responsible for it. And those are powerful findings. However, the judge also looked at the text of Section 3 of the 14th Amendment, which obviously was written a long time ago, and is inartfully drafted for these purposes, as we might say. So she's struggling with this language that was designed for the Civil War, where lots of elected representatives had rebelled, and we're trying to figure out what to do with them. But the president, Abraham Lincoln, didn't. So the people drafting that weren't thinking about what just happened here. That's what makes it a hard question. Yeah. So the judge, I think, carefully analyzed the language. She ended up going with an argument that had been out there, that had been made. I heard it mainly by former U.S. Attorney Michael Casey, who made pretty much this exact argument. There are strong counter-arguments as well, including. Yeah, but that's where she landed.
Marcus, I'm asking on that point. I mean, we're talking about the validation of having this finding, but we can't look at it in a vacuum, can we? I mean, he's got criminal matters that are happening, including one involving January 6th, right here in Washington, D.C., under Judge Chutkan, just to name one, right? The election subversion cases as well, including what's happening in Fulton County. Could what happened today in Colorado have an impact on those?
I mean, speaking of the parallel proceedings, it was pointed out in closing arguments, but former President Trump argued for removal in the New York case, the New York bank records case. And part of that argument for removal is he's an officer of the United States. But now in this, he's saying he's not an officer of the United States. And this was brought up by Noah's team, and clearly wasn't persuasive for the court. But I would imagine on appeal, I would hammer that point home because you're making contrary arguments depending on the jurisdiction. And so while it may not be expressly stated in the 14th Amendment, right, they're not being consistent with their arguments, at least to the court.
I guess you guys say you can't have your cake and eat it too. Well, we'll see what happens there. Thank you, both of you, so much.